Okay, listen up. If you're prepping for the Queensland bar exams, there are some topics you just can't gloss over, and this is one of them. We're diving into the consequences of failing to disclose documents under the UCPR. Trust me, these rules aren't just about procedure. They get to the absolute heart of what makes a trial fair. So let's make sure you know this stuff inside and out.
Everything, and I mean everything we're about to talk about, comes from this one simple, powerful idea. Justice Kirby nailed it. Modern litigation is a cards-up game. The whole point of disclosure is transparency. It's about making sure cases are won and lost on the facts, not because someone was hiding a trump card up their sleeve. The examiners will absolutely expect you to understand this core philosophy.
So, here's our game plan. We'll kick off with the core duty, then jump straight into the nitty-gritty of Rule 225. After that, we'll look at what happens when things get really serious, the court's ultimate sanctions. We'll tackle the huge issue of destroying documents, cover your personal duties as a practitioner, and then wrap it all up with the key takeaways you need to smash the exam.
Right, so just remember, this cards-up duty is so fundamental that the rules have some serious teeth for anyone who tries to play hide-and-seek with documents. So let's get into the rule you absolutely have to know.
Okay, Rule 225. This is the big one. This is the cornerstone you need to commit to memory. It's split into two crucial parts. First, what happens to the party that fails to disclose, and second, what the innocent party can do about it. Let's break it down.
First up, the penalties. You'll find these in Rule 225, Subrule 1. Number 1. They can't just whip out that document in court. They need the court's leave, which is a huge gamble. 2. They could be found in contempt of court, which is about as serious as it gets. And 3, they can get slapped with a costs order. So that's Rule 225, Subrule 1. No tendering, contempt, and costs.
So what about you? What can you do if the other side isn't playing by the rules? Well, Rule 225, Subrule 2 is your toolkit. You can apply to have their entire case put on hold or even thrown out completely. You can apply for a judgment right then and there. Or, and this is the most common path, you can get an order from the court forcing them to hand over the document by a specific date. That's your power, right there in Rule 225, Subrule 2.
Now, here's a classic exam-style distinction for you, and it comes straight out of the Mango Boulevard case. Rule 225 is your specific tool for disclosure failures, but you also need to be aware of Rule 374, which is the court's general power to enforce any of its orders. And here's the kicker. If you get a judgment under Rule 374, it can only be set aside on appeal. That's a much, much higher hurdle than for a judgment under Rule 225. It's a subtle point, but it's a game changer.
So what happens when a party just keeps ignoring their duty? When they're in persistent breach? Well, that's when the court brings out the big guns. We're talking about ultimate sanctions, things like guillotine orders and summary judgment that can literally end the case on the spot.
A guillotine order is pretty much what it sounds like. It's brutal. It's the court's final warning. The order will basically say, you have until 4 p.m. this Friday to disclose these documents. If you don't, your claim is struck out, automatically. There's no second chance, no coming back to court to argue. The axe falls the second they miss the deadline.
And this quote is fantastic because it shows you how judges think about this. They're actually quite reluctant to just hand a victory to one side as a punishment. The court is much more comfortable striking out a plaintiff's claim, basically telling them to go home, than it is entering a judgment against a defendant that might be factually wrong just because they didn't, play the game.
So, here's the crucial point. When does the court take that extreme step of entering judgment? It's not about punishing someone. It's about when one party's failure to disclose has so completely wrecked the process that a fair trial just isn't possible anymore. At that point, the court has to step in to protect the very integrity of justice.
And that gives us the formal test, which you'll see in cases like Alder versus Koo. This power to grant summary judgment is an extreme step. It's only exercised with great care and extreme caution, and only when that failure has genuinely jeopardized the fairness of the trial itself. The bar is set very, very high.
Now we move to the cardinal sin of disclosure. We're not just talking about failing to disclose a document anymore. We're talking about deliberately destroying it. This is considered the ultimate abuse of the court's process, especially if it's done before a case has even been filed.
And that's the million-dollar question, isn't it? The rules of disclosure technically only kick in once a proceeding is underway. So what happens if a company knows it's about to be sued and starts shredding documents left, right, and center? What can the court do then? The famous, or maybe infamous, McCabe case is the textbook example of this. You had a defendant with a so-called document retention policy.
But what it really was a systematic plan to destroy damaging documents precisely because they knew litigation wasn't just possible, it was a near certainty. This is exactly the kind of conduct the court has the power to stop.
And here it is. This is the legal test you need to write down and remember. From the appeal case of BAT v. Cowell. For a court to step in and strike out a defense because of pre-litigation document destruction, that conduct has to be so bad that it amounts to an attempt to pervert the course of justice. That exact phrase is key. It's a high standard, but for conduct this serious, it has to be.
All right, let's bring this back home. This isn't just about what your client has to do. It's about your duties. As a solicitor and soon as a barrister, Rules 226 and 227 place obligations squarely on your shoulders as an officer of the court.
Rule 226 is dead simple, but absolutely non-negotiable. At trial, the solicitor on the record has to hand up a signed certificate, and in that certificate, you are personally confirming to the judge that you have explained the duty of disclosure in full to your client. You're putting your name and your professional reputation on the line.
Next, let's look at Rule 227, Sub-Rule 2. Now, this is a really practical rule that helps make trials run more smoothly. Basically, if a party discloses a document, they're admitting two things: that it's relevant to the case and that it's authentic. It is what it says it is. It saves a ton of time arguing about those basic points in court.
But, and here's the trap for young players, the classic exam question, does this mean the document is automatically in? Does this rule just blow away all the other rules of evidence? For instance, what if the document is pure hearsay? Does Rule 227 make it admissible?
And the answer, thanks to the Court of Appeal and Equus Corp., is a resounding no. Absolutely not. Rule 227, Sub-Rule 2, only gets you over two hurdles: relevance and authenticity. That's it. The document still has to pass every other test for admissibility. If it's hearsay, it's still hearsay. If it's privileged, it's still privileged. Don't forget that.
Okay, deep breath. Let's boil all of that down. What are the absolute must-know, rock-solid points you need to carry with you into the exam room and into your career?
Here they are. 1. The philosophy is cards up. Disclosure is non-negotiable. 2. Rule 225. Know the penalties in Sub-Rule 1 and the remedies in Sub-Rule 2 by heart. 3. The ultimate sanction, summary judgment, is an extreme step. It's only for when a fair trial is impossible. 4. For destroying documents, the magic words are an attempt to pervert the course of justice. And 5. Rule 227, Sub-Rule 2, gets you relevance and authenticity, but nothing else. Other evidence rules still apply.
And I'll leave you with this to think about. These rules on disclosure really force you to confront a central challenge of being a barrister. We work in an adversarial system, right? So where is that line? The line between fighting tooth and nail for your client and your paramount overriding duty to the court and the administration of justice. These rules, they tell you where that line is. Mastering them isn't just about passing an exam, it's about understanding the very essence of the profession you're about to join.